welcome all of you back to this, the final session of the second annual Max Planck Law Conference. As those of you who have been with us during the day know, we've been engaging with researchers at various levels of their professional development across the Max Planck Law Network on this compelling and ranging question of rights inflation or rights realization. We're going to continue that conversation now with a roundtable of several of the directors of Max Planck Institutes. And in that effort, we're assisted ably by Professor Anuscheh Farahat, who is a chair in public law, the law of migration and human rights at the Friedrich Alexander University in Erlangen, Nuremberg. Professor Farahat studied law in Frankfurt, in Paris, and in Berkeley. Her book on migrant citizenship and transnational migration in Germany has received a number of prizes and recognitions, including the 2015 Hermann Mosler Prize of the German Society of International Law. In Erlangen, Nuremberg, she leads an Emmy Noether research group on the role of constitutional courts in transnational solidarity conflicts, with significant, substantial support from the Deutsche Forschungsgemeinschaft. For our purposes, most importantly, Professor Farahat has enjoyed a number of residences at a Max Planck Institute, in particular the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, where she was a research fellow and then a senior research fellow, and now remains connected with the Max Planck Law Network as a senior research affiliate. And in that sense, she embodies the spectrum of the kind of work and research experience that we find among the members of our network. Professor Farahat has recently become engaged with the theme of our discussions today, beginning a research project on the question of rights overreach that had its inauguration with a workshop that she hosted on that topic last summer. And with that, I'm thrilled to be able to turn over the microphone to Professor Farahat, an old friend of mine and an able interlocutor for this esteemed panel for today's Directors Roundtable. At the end of today's session, we will hear some closing remarks for the entire program from Professor Vogenauer. But for now, Professor Farahat, thank you.
Thank you very much, Russell, for this very kind introduction, and also, of course, for giving me the chance to participate in this really great project. I would like to apologize first for not being able to participate in any of the events this morning. This was due to some teaching obligations virtually in Erlangen. But I really think that it is an excellent program, and I also think that the discussions that you just started about the topic of rights inflation or rights realization is really a very important discussion. I think that we can see that the critique of having too much human rights or having human rights jurisprudence overreaching into the political is gaining ever more ground, and that today this critique can no longer be said to be somehow confined to right-wing populist movements as it used to be, but rather human rights inflation is a concern that is broadly shared in academia from various perspectives. And I therefore think that the choice of that topic is really excellent, and I'm very much looking forward to the discussions today. I feel honored that I was invited to moderate this really distinguished panel of Max Planck directors. And before we get started, I would like to briefly introduce our speakers or our panelists today. So I will start with Professor Marie-Claire Foblets from the Max Planck Institute for Social Anthropology. She's there the head of the Department of Law and Anthropology. And she's very well known for her research in the field of migration law, which is also where we met first, and where she has enriched the classical legal perspective by a distinguished anthropologist approach. And she has recently also published a book on humanitarian admissions to Europe together with Luc Leboeuf. And she has, on top of that, also extensively published on the freedom of religion, another top human rights topic. Thank you for being here and welcome. I would then like to introduce to you Professor Dr. Ralph Poscher. He is a director at the Max Planck Institute for the Study of Crime, Security and Law, and they're the head of the Public Law Department in Freiburg. And of course, he's known to most of us for having recently assumed authorship of the definitive German textbook on constitutional basic rights. But his work is also focusing particularly on the methodology of rights interpretation, that is, hermeneutical practices that are also a key element of discussions about human rights and, of course, also human rights overreach or inflation. I would also like to introduce and welcome Professor Dr. Hélène Ruiz Fabri from the Max Planck Institute in Luxembourg for International, European and Regulatory Procedural Law. She's there the director for procedural law, and her research deals with a very broad range of, an impressive broad range of international law issues, among these such diverse fields as international investment arbitration, international economic law, and human rights law. Her research displays, of course, a particular interest in procedural aspects, and in one of her recent publications, she analyzes how international courts and tribunals are exposed to a distinct procedural cross-fertilization pull. And finally, Professor Wolfgang Schön, he is the director of the Max Planck Institute for Tax Law and Public Finance in Munich, where he heads the Department of Business and Tax Law. While Professor Schon is, of course, best known for his research on tax law, he's also an experienced expert in business law with all its international dimensions. And he's particularly interested in how human rights, or at least also interested in how human rights impact on those economic activities and freedoms. Welcome to all of you. And we've just discussed in the beginning that we will get the discussion started by a question to each of you. And I will start in the order that I have also introduced you, and would like to start with a question to Professor Foblets. So you have recently written about the complicated intersection of state-centric norms for religious freedom and individuals and communities' lived experience of religion. Can you describe the problem with which this work particularly engages? And is it a problem, or is the problem that you describe a product of too much human rights talk, or is it rather something about not enough human rights talk?
Well, first of all, thank you for this invitation. And I think all of us have been reading this invitation as a kind of really an encouragement to think through. No? Is it about not enough? Is it about too much? I think for me, it's when we really think of the way that we protect the freedom of religion, which is the freedom to believe, but also the freedom not to believe. It's probably not a matter of not enough or too much, but whether the way we protect fits with the new realities. And I see in particular for the freedom of religion, there might be a kind of stagnation in the way that we are thinking about the new reality. On the one hand, we have in Europe this historical reality that religion is one of our best protected freedoms. It's historically also the first protection of a minority, no? The right not to be persecuted, or at least not to be persecuted by the state for your convictions. And we have in many countries constitutionalized that freedom. And what we see today is that the demography is rapidly changing. On the side of the majority societies, the secularization, and we have these freedoms of religion protected in the constitution, institutionally protected. And there is a kind of anachronism about this freedom, while society is secularizing. And then we have these new groups among us for whom religion really still means something, because they come from a background that is not really in the secularization mood. And there you see they lack really the institutionalization as a protection. So these protections are not being granted to them, not yet being granted to them. That I would say there is not enough. And this creates real tensions in our societies. And so what sometimes happens is that then people who would really like to be protected depend on strategic litigation. And so this is a very unoverviewable field. There is a lot of proportionality, balancing interests. It creates really a lot of tensions, both on the side of the majority society, but also as we see it, well, think of France, what is happening today, this week. Is it enough? Is it too much? It's, I think, not appropriate. So this is the way I would reply to your question.
The typical Zoom thing. I was still muted. So you would say that in the end, too much or too little human rights talk is not really the core issue, but it's rather a question of how we deal with human rights and how we realize them.
I think it might be also a matter of time. Migration is in the sense of the post-World War migration, a recent phenomenon. And many of these communities are not yet represented in the parliaments, are not yet really in the judiciary. So the discussion about their presence and the way that we think of the appropriate protection is something that we have to do with them, and not only through strategic litigation or the kind of tensions we have today, extremely mediatized, extremely essentializing, which is not reflecting these minorities deeply. And here is, of course, me, the anthropologist, speaking. So maybe it's a matter of time, but for the moment, the protection is not adequate.
I take from this also a reminder to all of us that probably one of the problems that we are witnessing is also how well discussions in society take place, and also what role, let's say, political compromises and open political debate has. But I think, but you also alluded to proportionality as an instrument that is perhaps possible to, well, adjust the application of human rights in the concrete case. And that, of course, brings me to Professor Poscher, who in his work, as I already said, well, very much insisted on how we actually do legal research, or how we actually do work with the law. And as far as I see, one of the core, well, export products of German legal scholarship in dealing with fundamental rights is precisely the principle of proportionality that has become one of the preferred interpretive paradigms for engaging with rights. Why do you think is that principle so successful? And do you think that this is really that this is a positive development, or do you also see some problems that could relate to the topic of rights inflation, or also overreach when talking about the application of the principle of proportionality?
Yes, I think in a way the principle of proportionality is a big success because it's a necessary addition to the protections of fundamental rights that we have, which most of the time include a provision that they can be curtailed by the legislator. And then a systematic problem arises: how shall the legislator be bound by fundamental rights which allow the same legislator to limit fundamental rights? And this is where proportionality comes in as a solution to this problem, to bind somebody who is in the position to limit some right by this exact same right. So I think that is the kind of big innovation that propels the reception of the principle of proportionality. And that seems to be, as far as proportionality is only seen as a means to have a kind of a rationality check on infringements of fundamental rights, not very problematic. It all depends then on how far you take the proportionality analysis, would be my point. And often it's propagated that you have to take it to a point where it comes to a case-by-case optimization requirement of different rights. And that seems to be a problematic development. What is, I think, called for, and what happens very often under the guise of the principle of proportionality, is that these are the lucky cases, that for specific fundamental rights, the principle of proportionality functions as an instrument to develop more doctrinal structure for individual fundamental rights, which is usually done under the heading of proportionality in the strict sense, or the very balancing operation. And if it goes well, I think it can help to shape individual fundamental rights in a doctrinal fashion that gives it some grip also against legislative intrusions. I think this is a dynamic that's running behind the principle of proportionality. But that is a very difficult task, to develop fundamental rights in this doctrinal way. And I think one way out is to go on a balancing mission case by case, and then just shapeshift between balancing and granting margins of appreciation. And I think it's even more difficult in an environment where you have, in this sense, an expansion of fundamental rights, also that you have more and more levels of fundamental rights that you have to integrate. And where I see a very specific challenge from this doctrinal point of view to the expansion of fundamental rights is not only how the institutions have to accommodate in their battle for their own stake in this fundamental right debate, but also at the level of each institution, of each court, of each commission, to develop a doctrinal concept of fundamental rights that is attuned to their specific level of fundamental or human rights guarantee. And not to just be an alternative to some conception on a different level. So I think it's, for example, very challenging for the European Court of Human Rights to develop doctrinal structures for the fundamental rights that are, or human rights that are entrusted to the court, that does not just overrule national fundamental rights conceptions, but to find a level of attunement of their doctrines that is specific to their level of review. And I see that as, from a doctrinal standpoint, as a very challenging task for those who have to tackle it.
Yeah, I think indeed it's a challenging task also because the number of actors in human rights protection and the number of institutions that are well established to supervise human rights compliance is also well skyrocketing more or less over the last years, so that makes it even more complicated. But it also brings me to a research interest of Professor Ruiz Fabri, who is concerned with a trend, as I already mentioned in the introduction, towards a stronger proceduralization of human rights protection. And so the problems that Professor Poscher just mentioned, as far as I have understood your claim correctly, to my, at least in my view, have a clear link to this proceduralization pull, as the courts, such as, for instance, the European Court of Human Rights, are reacting by developing new forms of proceduralization to somehow come to terms with their specific role and also with the number of cases that they are facing. So in that sense, maybe you just want to introduce a little bit your point on proceduralization here, and whether you think, Professor Ruiz Fabri, whether this is a contribution to combat human rights inflation, or whether it's yet another form of human rights inflation that we're witnessing here.
Yeah, maybe I should start by saying first to thank both Ralph and Gilbert for the organization of this conference and panel, and for the invitation to participate in this discussion. I have to say that probably we have to distinguish between these different things. And when I speak about cross-fertilization, I speak about courts borrowing solutions from one from the other and taking inspiration on the case law of other courts. And proceduralization is another issue in my view. And the problem is what you mean when you speak of proceduralization. And you can have two different visions of proceduralization. One is the rise or the development of procedural rights, and the other is proceduralization of rights, which can be heard as bearing a kind of pejorative connotation, at least to a certain extent. So probably if we speak about the development of procedural rights, I would say that their existence is not new at all. So I won't develop maybe this aspect, maybe later if you're interested. But nevertheless, it's interesting to recall that systems, that the common law systems were precisely born to offer remedies. So they were born on the idea of procedure, exactly for people to be able to have their rights taken into account, even if these were not called human rights at this time, but you can have other types of rights or obligations. And so I have no problem of speaking of procedural rights, and I think that they are as important as substantive rights in many respects. Now, if you speak of when you speak of proceduralization of rights, if you mean that substantive rights are like primary rules in the Hartian meaning, and they are accompanied with procedural rules which help guaranteeing their respect and implementation, then at first glance, proceduralization is a good thing because it avoids that proclamations of rights remain hollow for lack of concrete guarantees. And so, but if you mean that rights become trapped in a procedural net of rules which introduce a managerial tone in human rights, then proceduralization might impede rights more than support them. So I don't know whether we can say that proceduralization as such triggers or a way on inflation of rights or less rights. This is something I'm not able to completely decide or have a definitive opinion on that. So I don't know to what extent I answered to your question there, but this is a distinction I think is important. And there I'm not really able to make any hierarchy, because what was striking to me was that what Marie-Claire Foblets was saying a moment ago about understanding the level at which we should provide protection, because it might be that the protection we offer, including with the principle of proportionality and very nice tools to assess the respect of rights, turn out not to be adequate because the way they are addressed to people make that these people cannot seize their rights, you know. And so the proceduralization, there's exactly the same problem there. I mean, you can offer a lot of procedures, but face people who are not able to use these procedures to exert their right and have them implemented. And so this is where I completely share Marie-Claire's views about the fact that strategic litigation cannot be the only answer to this problems.
No, I think that you made an important point. I think that proceduralization is on the one hand key to allow an effective implementation and realization of human rights, but that at the same time, of course, it can also pose new obstacles and problems. So I think that's an important point. I would like to bear it in mind for the perhaps second round of our discussion. But since all of the first three speakers somehow got around a clear statement on whether they see human rights inflation or whether they don't see it, I would like to turn to Professor Schön, who, in the preparation of this session also said that this is where it somehow expressed that this is perhaps not the right question to talk about human rights inflation, but I think who has a clear position as to the question of obligations inflation, which is a term that he raised himself, or no, I don't know. Don't think that he raised it, but I took it from his emails. So constellations where you see an overwhelming burden of formal and substantive obligations for private actors, and who describes that as a core problem, also perhaps being a result of human rights inflation, or at least human rights jurisprudence. So maybe you can explain a little bit to us what you mean by that and what your core concern here is, because I think that although you said it's not really about rights inflation, my gut feeling was that there is a clear link to that.
Well, I'm happy to talk about this. Can you hear me, everyone? Is that okay? Yeah. Well, thanks for having me. I'm kind of the odd child out here because I live in a world that is not so lofty and high level as humanitarian law in a general sense. It's basically about people earning their money, businesses delivering their services. It's the world of taxation and of corporate law. And if you ask people out there whether what they witness might be called rights inflation, etc., the answer might be quite different, also depending on country by country basis. Interestingly enough, we have a very strong movement at the global level to talk about taxpayers' rights. There is an enormous movement, in particular in developing countries, but also in former communist countries, where people talk about the evolution of taxpayers' rights vis-a-vis the state, because taxation is clearly where the state gets in contact with all of its citizens. It goes way beyond criminal law or police law or other areas of public law when it comes to the broadness, the breadth, and the, I would say, the fullness of the interaction. And when I talk to lawyers from other countries, I hear that they want to have a right to be heard, they want to be some fundamental protection, they want to have access to court procedures and everything. But that's not the problem in Germany. In Germany, when I look at taxation and business law, there are some very nice rights in place. These rights are neither overextensive nor underextensive. But what we see happening and what people simply don't get on with anymore is an inflation of obligations. And this inflation of obligations has to do with control. It's the state wanting to get documents, to get filings, to get information at a very large scale. It's about shifting responsibilities. Just to give you an example, we had a fair number of corporate scandals. Those were really scandals, but these scandals have led to legislation and court practice that have established a network of formal obligations for all businesses which exist. And I think we are reaching a situation, we are very close to a situation where this network of obligations cannot be handled anymore, both by those who are under the obligations, which means private actors, and which has become far too complicated and difficult to handle for the state authorities, which again brings us to a very uncertain, insecure, arbitrary situation. Now, has this anything to do with human rights and human rights inflations? In my perspective, no. What I clearly see is that in other areas of the law, the obligation of one person corresponds to the right of the other person. And then you have complicated situations. In the area of taxation, it's the state against the individual. Of course, the state represents the collective of individuals, that's for sure, but it's basically a vertical situation. And I think we have to consider this in earnest. We need, of course, some human rights protection, but I do not see a clear necessity to strengthen or to reduce human rights in, let's say, or in the European Union or in Germany when it comes to the area of taxation. But we clearly need a reduction of obligations.
I think the point where, thank you, I think the point where I thought that there is a link between human rights inflation and the inflation of obligations, as you called it, is precisely where human rights or where obligations result from a respect for human rights. This, of course, is something that at least in some instances also applies to businesses, at least to a increasing degree today. So I think that we can perhaps see a link here, although of course not all formal obligations are the result of human rights jurisprudence or a result of human rights or are the correspondence of a real human right. But nevertheless, I think if we go back to what Professor Poscher said, that rights can be managed through proportionality, then maybe what you're witnessing as or describing as obligations inflation or the inflation of obligations, maybe that can also be managed by proportionality. Would you agree? I will first let you answer and then give Professor Poscher the opportunity to answer that question.
Thank you. Maybe I would like to first come back to your first point about this interaction between obligations and human rights. There are some situations. Currently, we are discussing legislation in Germany about human rights protection in the supply chain, making multinational enterprises responsible for everything that happens, not only within their own firm, but also with independent suppliers, etc. That might be an example, but it's only one example among many, and most of the others are not related to such huge human right dimensions. When it comes to proportionality, well, that's one thing. My buzzword would be consistency. If the level of obligations and the whole network of obligations comes from a background that is inherently consistent and which does not duplicate and intersect obligations in a way that they are not available for handling anymore, that would be a good thing. But I currently see that it's not only the sheer quantity, it's also the disconnectedness and the many different sources of obligations that make life hard for individual actors.
Yeah, my feeling is that what you require as consistency is something that probably even overburdens the principle of proportionality. So that would be my initial answer to that. But I would be interested in how Professor Poscher sees that, whether proportionality can really help us to bring some sort of coherence in the sense that Professor Schön is wishing for.
Well, first, I mean, I could give an example where, I mean, my approach to this expansion question is not only hinged on proportionality. And to give you an example for that, it's the whole idea of how can you develop the vast array of fundamental rights protections in a doctrinal way that it comes to more than ad hoc decisions. And where things can also go wrong is by misconceiving a fundamental right. And a fundamental right that is misconceived, I think, and which leads to many obligations, which we all sometimes at least think are totally hollow, is the right to data protection as a separate and essential fundamental right, which it is not. It is an enhancement of other fundamental rights. But if we substantialize this right, it becomes a formal procedure that every and each handling of personal data has to be either either be provided for by law, or we have to consent with these constant clicks that we now have to perform to keep on going with our lives. And I think that is also, it's a way where we doctrinally, I think, took a wrong path with a certain fundamental right, which leads to a ton of obligations, which are for huge parts or for large parts ring hollow to us, and for good reason. So I think there can be this connection. I think data protection is one of the areas where I see this link, and where something I think went off the rails. And that cannot be then accustomed only by reverting to proportionality analysis. Has to be an analysis of what is the substantive behind this idea of data protection, and that is a totally different analysis and a totally different doctrinal work than just a proportionality analysis. So that would probably be my answer, that we have to be careful how to develop fundamental rights, and that they do not become hypostasized like this data protection right, for example.
Yeah, I think you're totally right in describing this the problems that we also have in applying the principle of proportionality. When talking about proportionality, I always have the feeling that the expectations that we can actually produce a coherent and a rational result. You mentioned that in your first intervention when you said that the principle of proportionality is supposed to also bring about some form of rationality. I think that is an expectation that that we have also sometimes of procedural law, but where I would where I ask myself frequently whether some of the decisions that are taken by recourse to the proportionality principle are not in fact decisions where we need really a political debate. So where rationality is not really the right standard to measure a political decision. So is that something that you would subscribe to? So that sometimes the expectation of rationality is a bit misguided in light of the inherently political nature of legislation?
Yes, I think there's only so much in rationality that you can squeeze out of the proportionality principle. That you do not employ means that do not contribute to your end, well, sure. That you do not employ excessive means which you could, at lesser cost for a fundamental right, achieve an end with a less intrusive means, sure. But then already with the standard of proportionality in the strict sense, it becomes more difficult. You have the incommensurability issue, and I think there's only so far that you can really get with a strict proportionality approach. And I think most of the decisions that rely on proportionality have nothing to do with this sense of rationality control, but they are rather, I think, attempts to either decide on a case-by-case balancing to make an alternative, a kind of a policy audit decision, or, and that these are the more interesting cases, to develop within the proportionality principle doctrinal structures for certain fundamental rights. And it was already at the birth hour of the principle in our jurisdiction when they applied it to the right to follow a profession, that they worked with the phrasing of the guarantee, that they developed 3 different levels of protection of this guarantee, and they all did it within the framework of proportionality. But what they really did was to give this fundamental right some structure and some legal bite. And I think these are the more successful stories of how to deal with the principle of proportionality to develop. And there it comes back to Mr. Schön's point that that you have to develop coherent doctrines within the principle of proportionality for specific fundamental rights. I think that is what the more optimal decisions of the courts when they apply the principle are about, and to shape the specific fundamental right doctrinally. The decisions that you can reconstruct as a strict rationality check, they are probably not the most important ones. And then there are many decisions which can be seen as problematic because they fit neither the rationality control nor the consistent doctrinal shaping of a fundamental right.
Thank you. I'm following also the Q&A session, and now I have to deliver one of the questions of Anne Peters. I will get to the other ones if we have time also, but her last question was, we should ask the non-German panelists whether this has been a totally German discussion about proportionality review. So I'm happy to give the non-German panelists the chance to answer that question.
Hélène, you take the lead?
Oh, I can take the lead. I have to say that indeed, I was thinking it was a very German discussion, you know, and because I know that proportionality principle was a gift of Germany to Europe and more broadly to many international courts. Nevertheless, all the discussion I've just listened to sounded to me indeed very, very German. And in a system where people are used to having fundamental rights discussions approached by the Constitutional Court. And so it shapes the discourse a lot. If I speak about the proportionality principle as I see it from the point of view of international law, not only human rights, because it's used in other fields, then I might have probably, I might present things a bit differently and focusing more on the balancing exercise, but also on the political dimension of proportionality. So I would see it in a far more instrumental and maybe neutral way, in the way that I think that with proportionality you can do a lot of very different things, looking for strict proportionality to just a mere disproportion. And I would say the range of outcomes that you can have and the depth of the control you can exert with the principle of proportionality can be very diverse. And so this is where I would say I agree that there is no direct link between proportionality and rationality, because you can put very different rationalities under the heading of proportionality, in my view.
I would like to qualify the question for Professor Foblets a little bit, because I would like to ask her not only as a non-German trained lawyer, but also as an anthropologist, whether this idea of rationality check and proportionality through proportionality review is really something that we can universalize in such a way. After all, rationality is something, one could argue that rationality is something very, very relative in terms of cultural background and so on and so forth.
Well, I've been listening carefully to the different interventions on proportionality. When we think of what Anne Peters said, there is only one absolute human right, which is the dignity. It means that most of the other rights need to be balanced. And this gives really proportionality its role of management, not technique. It's a balancing of interest. It's in fact justice made to measure. And I think we need such an instrument, but all depends on how often do we have recourse to this. And I think you were so right, Anuscheh, when you said, don't we lack the parliamentary democratic dimension in this exercise? And this was what brings me back to the research that we are doing here at the Institute, how for people religion is relevant, how they experience this, and how they then bring this importance to them, to judges in secular justice, who have a difficult, very difficult task, balancing exercises. And when too many cases depend on the judiciary, you get a kind of, not politicization of the judiciary, but the wrong expectation about judges are really sometimes asking the judiciary is overburdened and wants legislator to intervene. And I just think of well, we all know it's front page news, for example, the headscarves. And what you then get is legislators take over in a less nuanced way, and there is prohibition. And there is then very much eclectic criminalization of religious behavior. So I think proportionality, we need it, absolutely. It's justice made to measure, but maybe in a proportional way. I mean, it should remain something that is not the structural answer, because it lacks the democratic debate. And judges cannot be the legislators. So I think your question was so well put, Anuscheh. And for example, a field where you really see the proportionality test is in the reasonable accommodation. Access to the labor market. Can a person, for reasons of belief, be exempted from? And it's really the balance of interest between freedom of enterprise and the freedom of religion and the freedom to be protected in that religion. And then you see completely different positions taken by the court in Strasbourg and by the court in Luxembourg. And there is a problem there, because that is really the kind of the proportionality being weighed in a different way by two Supreme Courts. I think that's really what I wanted to say in my first kind of intervention, is there is a difficulty. It's not about too many rights or not enough rights, but it's the way that we deal with these rights. So that would be my answer for the proportionality. Yeah.
So we should not hide behind human rights because we don't want to answer the complicated political questions behind, right?
And relegated to the judiciary. Yeah,
yeah, which is the inevitable consequence of that. That also brings me to another question that somehow links to another question that has been posed in the Q&A. So my impression, so Wolfgang Schön was speaking about obligations, inflation, and also about well, how there is too much responsibility, perhaps also for human rights, although I think we got it clearly that it's not only about human rights. I think it somehow seems to be in conflict with a different reading, which is that the increasing importance of human rights and also of human rights obligations is rather a reaction to the absence of sufficient state regulation. And so the absence of proper democratically legitimated and also properly deliberated decision-making. And how would you respond to that idea?
Well, actually, as I said at the outset, countries differ enormously in this respect. And there are countries where you have basically no state regulation, no human rights protection, powerful private actors and monopolies controlling the state. Those are, of course, countries where you have to introduce both human rights and obligations vis-a-vis others and vis-a-vis the state. Insofar, it may well be that my contribution was a bit Germanic in the background, but it's not only the German situation. It's to a certain degree, many countries within the European Union see this inflation of obligations. And if I may one last time refer to proportionality, one big lacuna in German constitutional theory and practice lies in the fact that the cumulative effect of obligations is not really captured by our doctrine and by our court practice. So each and every obligation on its own merits may be appropriate and necessary and balanced and not go beyond what is adequate. But the cumulative effect is basically not addressed by our courts and by our doctrine. Maybe I can link that to what Anne Peters just wrote about basic obligations and responsibilities. I absolutely see your point. I couldn't agree more. There are some constitutions around the world where you have notions of fundamental obligations. The most prominent one, by the way, which has been forgotten in some countries, is military service. And of course, paying taxes, but also other notions of solidarity. But that's a distinct thing, fundamental obligations in the sense of basic responsibilities. That is something I absolutely agree with. But that doesn't mean this overarching and overly complicated network of statutory and judge-made obligations which private actors now are facing.
It brings me to two more questions. So one would be, but only one of them is for you. So one would be, if it's true what you're saying, that the situation in all over the world, of course, differs from country to country, and that there are some, well, countries that are performing rather well in terms of human rights protection and others who don't, isn't the fact that it is possible, or what we are seeing and what the legislator is, at least in my view, reacting to with the corporate regulation of corporate responsibility, isn't the fact that private actors can evade some of the obligations by cooperating with other states or by outsourcing things to other states? Isn't that precisely one of the problems why we need more, at least on the global level, more obligations? Or do you see other ways how to respond to that problem?
Well, actually, now we are entering a major field, mainly regulatory competition. If you have 200 countries in the world, each setting their own standards, and each influencing cross-border traffic by setting those standards, then it's extremely hard for a single country or even a single group of countries to react to that. I fully see that, for example, major enterprises can be held responsible to a certain degree, for example, for the compliance of their supply chain with certain human rights. But one cannot go too far in this context. And if control is simply not possible anymore, if international traffic is more than just abusing or avoiding domestic legislation, but simply also a means of creating efficiency and providing goods and services to people around the world, then we have to strike a balance again. But that brings us really to the whole theory. It brings us to Dani Roderick's trilemma. If you want to interact in a global world, it's very hard to be a democratic state, a self-controlled state, an efficient state, and an internationally connected state at the same time. You have to make choices, hard choices, and making these choices, you should be really careful about what you can do to your own private actors.
Yeah, I don't, of course, want to go deep into that discussion, but I take from this at least that perhaps to expect human rights to solve that that problem or that entire conundrum is perhaps well, overburdening them with high expectations. So that at least I think we can take from that. I would like to get also to another point that is linked to what you said before. So you said that the situation, of course, in different countries is different, and that and Marie-Claire Foblets also in her first intervention and also in the second talked also a little bit about the cultural impregnation of law. And my question would be, first of all, to Professor Foblets, and then perhaps also to Professor Ruiz Fabri, in how far it actually makes sense to speak of universality of human rights, because I think that's the criticism of universality is one of the threats of recent criticism of rights inflation and overreach. So to what extent does it still make sense to speak of the universality of human rights? In how far do we need to somehow adjust these concepts regionally? And in that respect, of course, the question to Professor Foblets is, well, generally to fundamental rights, and to Professor Ruiz Fabri, perhaps also about the emergence of a more universalistic set of procedural rights.
You opened the box of Pandora with universal human rights, of course. And maybe I think that the compromise position is that also in anthropology, it's not because anthropologists are fairly critical of this kind of universality kind of approach, that they drop, so to say, the human rights. I think they look at it in a more aspirational way, which is, let's not give up on them, but let's see what you get if you just impose the universality in a too doctrinal way, here and now. And this brings me to a number of examples. What we have in Germany now is, for example, the whole issue of early marriage. The people that marry at a very early age in the country of origin, flee to Germany, and it was front page news. What do you do with these marriages? And here you see this kind of, when people move from one world into another world, where the context of the protection, where the balancing of interests is completely different because of the context, not because of these people disregarding human rights, but because the protection is the first need. And an early marriage, for example, is the way to protect an individual. And of course, from our point of view, it's denial of all types of opportunities. It's all but emancipation. It is oppression. It is not really consented. It is imposed. It is, and all these nuances, we should not get rid of them, but we should also know why these early marriages are such a persistent practice. It's because of the context. And then in the migration context, the very, very question is, shall we grant effects to this marriage? And here, these are for me the questions of the universality. They don't deny that they might be much better off. And Ann Peters was so right in her way to present this kind of outcome. When people are well off, when you're in a welfare state, then of course, freedom of choice, I mean, this kind of self-determination becomes ever more important. But as long as the conditions are not there, we should not blame these parents for marrying their daughters. They do for the best. And this is what interest of children is. The parents do for the best within the constraints of the context. And so I just bring that example because it was front page news in Germany. Can these two people married validly in the country of origin continue behaving like married people in Germany? And then the whole issue of proportionality. What comes first? Our public law and order, but then you produce a limping marriage. They can't live like married people here. And this is not really a support to these people. So these are the questions about universality. I just brought that one example, but we all know so many other examples. How difficult it is. We should not give up on universality, but we should probably be more thinking of it in the context and in an aspirational way. That would be my answer. Yeah.
So more contextualization combined with universality, or with at least the aim of universality.
With not giving up on universality.
Mm-hmm. Is there also a universality claim in procedural law?
Yeah, and more generally, international law faces exactly the same kind of criticism and undermining processes. I mean, universality is attacked on all fronts, I would say, in the name of situated approaches. And so it's a general movement which happens here. And I think we have to keep in mind that it has an ideological dimension. It goes hand in hand with some values, and whether we want these values to be universal or not. There is a part of choice in that. I met this debate also when I worked on the diversity of cultural expressions, you know, because when setting up rules to protect the diversity of cultural expressions, immediately you face this, yes, but what you do with some traditions. And for example, you can say, okay, this is a cultural tradition in this country which deserves to be protected. And how do you combine this with human rights? I think, for example, for genital mutilations. And this is a cultural tradition. And do you accept to defend that because it's cultural? Or do you think that you defend cultural diversity only to the extent that it's compatible with human rights? I just raised this example to remind that in a way or another, you have to face a compromise, but having to face some compromise on nuances, just the way that Marie-Claire explained, doesn't mean that you renounce the universality of the basic values which are translated into human rights. This doesn't seem to me completely incompatible. And we have to be very careful not to renounce this mantra of universality, because it currently faces a lot of undermining discourses. In terms of procedures, I would say two things. One thing is that for sure procedures are very often culturally connotated. And if you try to convince a German civil judge that French rules are better than German rules, then it's a no-go, I would say. So you have this, it's deeply rooted culturally, the conviction that the way things are done are probably the best. And most of the time it's also deeply rooted because people do not even think about the political dimension of procedures. And so this for sure plays a role. But more than that, what I think interesting is that the rise of procedural rules have helped discussing the decision-making processes, which seems to me important. And then we are back to the idea of democratic processes or non-democratic processes. And also the rise of procedural concerns also highlight the fact that you can proclaim a lot of very nice rights. If you do not provide as well the means to defend these rights, you're almost nowhere. And I'm not able there to make any hierarchy. Let me just take an example. If you're starving, what is more important for you? The basic right to life, which is the primary rule, or a way or another to turn to someone to be the opponent or the respondent for this right and help you go out your starving, if I can put it like that. And it leads me to one last remark, which is that we speak about right inflation, but most of the time it doesn't mean that we have had multiplication of rights. What we have had is an expansive interpretations of many rights, carrying with them the development of positive obligations. And these positive obligations indeed increase a lot the burden, which is on states, especially regarding human rights. And I'm not opposed to that. I just wanted to underline this dimension because positive obligation is a never-ending process. You can always enlarge the burden for the opponent or the one having to respond for the respect of this right.
Yeah, I think speaking of human rights obligations of the state, I would also like to raise another point that, well, due to my own research, comes to my mind very often when we speak about human rights overreach. And as it happens, I have to give a speech about that as well. So I just use the opportunity to talk with you about that, which is the situation of migrants in the Mediterranean, where we have the situation that on the one hand, we have very difficult questions about jurisdiction, so whether human rights apply at all in that situation. But on the other hand, we see precisely the importance of access to procedure and access to, well, and also perhaps the obligation of due process in that respect. And precisely because the states are more and more trying to somehow evade the more obvious human rights obligations that they have in that respect. Do you see any silver line in procedural law which could be used for that situation based on your comparative research on procedural law?
But I think this is typically the kind of situation I mentioned previously. It's when you use procedures to manage human rights in a way which reduces access to these rights. And so you do not compromise the right as such in the sense that you do not deny the proclamation, but you do all what you can to avoid that these rights are indeed implemented. And so this is the managerial dimension of procedures, which is not necessarily the most sympathetic. And but this is a political choice. It's a political choice hidden behind procedure. And most of the time you hear this is procedure and you can say, okay, you do not want to do this, and you just deploy the procedural veil. But procedural rules are moved like any moves by a political will. So if we are so much after procedures for the migrants, it's typically because we do not want to take them in our countries. I say we, it's an over-generalization, of course, but I mean, this is the way of expressing what happens under our view.
I would like to give a last, well, perhaps last, I don't know, but a third question also to Professor Ruiz Fabri from the audience. Pedro Villarreal was asking a question. I just read it from the chat. So, in your research on cross-fertilization in international courts, have you ever come across courts referring to the balancing exercise per se of another court? And to what extent could the diverging scope of courts' jurisdiction lead to an overlap or even a clash of different rationales affecting how the balancing itself takes place?
Quickly, to the first question, the answer is no, no reference as such to the balancing exercise to proportionality. And it's also because the same kind of exercise can bear a different names depending on courts, where human rights courts or maybe the Court of Justice, the European Union will not hesitate to speak about proportionality. All international courts will hesitate to use the very word of proportionality, if only because it carries the image of an in-depth standard of review. And so this word is not very much used. You will hear far more of necessity or other vocabulary, but it can also be simply related to the wording of international treaties. But when you look at what was done when it still existed by the appellate body of the WTO and what is done by other international courts, the necessity test developed looked very much like a proportionality test, but without the name. You could find the same rationale. And there it is there that I come to the second, the answer to the second question. I've not seen open clashes, but I could see potential clashes, because when the appellate body of the WTO, for example, has to balance trade interest with the health interests, for example, its approach to health, or it doesn't speak about a right to health, but about the protection of health as a legitimate objective for the state. It might be that its approach to health is far away from the same approach by human rights courts. Mm-hmm. This being said, no case law which has gone in depth enough on these topics for me to say that there is an open clash, but potential clashes, yes. And it might be that precisely in these times of pandemic, the potential for clashes becomes even more obvious, because you will have this competition between states, and it will be in economic as well as human terms, for example, access to vaccines or things like that.
Thank you. So we're approaching really fast in terms of the time that is still left for our discussion. But I would like, instead of posing a general question to all of you, I would like to ask you, the panelists, whether you have any questions to any other panelists. So to give you the opportunity to ask something about perhaps the topics that we talked about today, but also other related things that come to your mind. Is there anything that comes up?
Yeah, maybe I would have a question for Marie-Claire, because when I listened to what she said, I really deeply understood what she said. At the same time, how do you fight against the risk of becoming relativistic?
What was the last word of your sentence?
Relativistic. I don't know if it makes sense in English. Sometimes it's just translate in a plausible word. Maybe Russell has a suggestion.
No, I think it's you understood it, right, for Marie-Claire?
Yeah. But let me try. I wanted to return, in fact, to the whole issue of the Mediterranean area, and so was preparing.
Okay, maybe if you can do that afterwards if you like.
Okay. But I think, Hélène, don't take me wrong, but in anthropology, what we of course try is to understand the norms of the people in the context of their world, and then you become, per definition, relativist, but not relativist in the sense of an everything goes position, but relativist in the sense that the behavior of people make only sense in relation to their world, to their balancing exercise, let's say. No? And these practices, and you refer to one practice that we all condemn, which is the female genital cutting, is something that, of course, we would like to get rid of. But what anthropologists do is try to understand why these practices are so persistent. The bodily marking, with all the pains that come with it, is a universal way of marking individual people as members of their groups. And the balancing exercise for these people is, if I do not abide by this expectation, I'm no longer a member of the group. And there are no other groups to protect me. So in a way, there is no choice. And this is what I think what Anne Peters was also referring to. If you don't have the framework of a state that protects you in an alternative way than the one that is the group to whom you belong, there is not much choice. And what you see is this kind of, these protests from inside these communities very often come from people who have a training, who are educated, who can afford to have an alternative way of thinking of themselves. But this requires critical thinking. This is a very difficult exercise for people. And so the persistency of these abominable traditions is to be explained within the context. And so don't give up on universality of human rights, but try to understand why for many people they're not affordable as yet. And this is my answer to your question. I would really like to adhere to universalism in a much more categorical way, but reality invites us to be a bit more, maybe prudent, I don't know how to say, a bit more realistic, a bit more relativistic. Yeah. But I don't know, Hélène, maybe next opportunity we should discuss this further.
I didn't get you wrong. I mean, I like very much your answer. I think it was important that all the audience got your answer, because I fully share your view. So.
Okay. So I think we have the time, at least I just take it, for 1 minute per panelist, just to have a final remark, one point that you find really important to explore further in that debate about human rights inflation / human rights overreach. So what is the one core thing that you would see further elaborated, and why?
I'll give the first shot. I would like to return to colleague Poscher, because I found him so much more optimistic about proportionality that I might give it a further thought on the first occasion we have to meet and to further discuss. So this is the lesson I draw from this, well, one of the lessons, but a very important lesson I draw from this meeting.
Maybe Professor Poscher, you just want to be the second and answer to that, or
well,
you don't need to answer.
I'm really concerned with this question, and it's not that I'm optimistic, but what I would like to drill into deeper would be, I think I have a fairly good impression how proportionality works within the German context, and I'm not so well aware how it works in other contexts. And if what I can see and identify in the German context also holds for other legal contexts. And I think that would be an interesting investigation for me, and we're doing a seminar on it. And I think that you can reconstruct proportionality in a certain way. You can understand where it stems from, what function it serves, and it would be interesting to see how that plays out in more detail in other jurisdictions than the one that I know that I'm very familiar with. And it's an open investigation. It's not that I'm optimistic about it. It's just that I would like to see how it plays out. Yeah.
You will let yourself be surprised. Okay, Professor Schön.
Yeah, thank you. I would like to come back to Anne Peters' questions about basic responsibilities, because the basic obligation to pay taxes, to contribute to the general good, to allow for redistribution, requires some notion of common good. It requires probably the definition of the community which is involved. And when we talk about human rights and when we talk about fundamental obligations, we always have to take care whether we talk about global concepts or concepts linked to smaller communities, whether it's the European Union, the United States, individual countries, etc. And you just mentioned in passing the situation of human rights in the Mediterranean, where even jurisdiction is at stake. So the links between rights, obligations, and membership in communities is something I would like to explore a bit more in the future, and that's what we are trying to do in part at the Institute.
Thank you. And Professor Ruiz, Fabri,
thank you. I would
to
like
close the session.
Yeah, to make a bit briefly 3 remarks. The first one is that we can see from our panel that it's really good that we exchange, because we all have different fields of expertise, and we can see how the discussion can become when we exchange on specific topics like that. So thanks, Max Planck Law, for this initiative. The second one is indeed related to what Anne-Peter explained, and especially that we could have very different concepts of human rights, whether we come from private law or public law, when this divide exists in our legal system, and therefore we need to try to overcome this divide by discussing even more. And my last remark is that I really don't like hearing about inflation, because it has a bad connotation in my ears. And I would like that we convince that the reason why we speak so much about human rights is also because they suffer so much in our current world. So I think that we should fight against this idea of inflation, and we discuss more about why some people speak of inflation, and be careful with our words. Thank you.
Thank you very much from my side as the moderator. I enjoyed the discussion very much, and I also drew a lot of inspiration for my own research on that topic. And I think there are a lot of good loose ends, if something like that exists, where you can continue thinking. And yeah, thanks to all of you. Thank you also again to Russell Miller for organizing all this. And with this, I would like to hand over to Stefan Foggenauer, who is now closing the program.
Well, this has been a very improvised annual conference. You will have seen that all the participants will have seen that the speakers, the PhD students, the postdocs, a constant revision of the program, a constant rejuggle. And I'm glad it worked out, and we spent 2 really interesting 2 half days. Yesterday, looking at the various projects and initiatives, asking you all to engage with the network. And I mean, engaging with the network doesn't have to be limited to those projects and initiatives that have already been mentioned and which had a dedicated breakout room yesterday. Perhaps that could have been made a little bit clearer. It's really your network to engage with. It's really up to you to come up with ideas, with grassroots initiatives, as Russell Miller called them. So do get involved. I think that was the message of yesterday. Now, this morning, obviously, a much more ambitious intellectual agenda with the session on rights inflation with a question mark, and to use the word that Hélène Ruiz Fabri doesn't like to hear, perhaps for a last time. Obviously, this gave a lot of food for thought, and it also showed me the limits of the virtual format that we're engaging in. I mean, I had a few moments where I would really like to follow up with Ann Peters over lunch now, but I felt it would be perhaps too trivial to type this into the chat. But well, is it really the case that religions are about duties only? Is it really the case that the will theory is a male dominated theory? So there's so many questions just from the keynote lecture, and then obviously the discussion afterwards through new spotlights on all these issues. I found it most interesting, and this is why I'd like to thank all the speakers, particularly this morning, Anne for her keynote lecture, all the directors participating in the panel. Professor Farahat, I mean, many of you really agreed at impossibly short notice to participate, and I'm truly grateful that you were also engaging with the network. The same obviously goes for the speakers in the first half of this morning and Professor Hanschel and all of those who contributed yesterday. Well, where are we going next? The outlook perhaps for Max Planck Law. We do hope to launch the curriculum as planned. We do hope to initiate the various projects and initiatives, and we do sincerely hope that we will have an annual conference in October 2021 in the Harnack House, but caution is certainly the order of the day. And perhaps I can conclude with a few words that Marie-Claire Foblets made earlier on. We have to approach all these issues at the moment in a more or less ambitious way, and let's not give up. So with those words, I'd like to conclude yesterday's and today's proceedings. A final word of thanks, of course, for Russell Miller and Gilbert Leung, who very skillfully and expertly navigated the two of us, the two of them very skillfully and expertly navigated all of us through these 2 days. Thank you very much, and I hope to see many of you very soon in person, and at the very latest, October 2021, Harnack House, Berlin. Thank you very much. The conference is closed.